Jury selection is now underway in Windsor, Ontario, for another high-profile criminal trial. 4 members of the Afzal family were killed just over 2 years ago in London, Ontario. A then 9-year-old boy was the sole survivor, and prosecutors allege a man deliberately rammed his pickup truck into the Muslim family during their evening walk. It sent reverberations of grief around the country and prompted calls to combat Islamophobia. I'd like to turn now to Abd Alfatah Twakkal. He is the chair of the London Council of Imams, and we've reached him in London, Ontario. Welcome to the program.
Thank you for having me, Anna.
I imagine this must be a tough day for the community. This violent attack happened 2 years ago, but it really feels like it was yesterday. How is everybody making out?
It is difficult, as you mentioned. It brings back a lot of the raw emotions that we felt when this horrific attack took place in our community in the first place. But we remain as a resilient community. We continue to be patient and to persevere through the challenges and the difficulties. And that's part of the message that we as faith leaders continue to provide to our community members.
Are you concerned that as details emerge from this trial, it could risk re-traumatizing the community and family of the victims?
Yes, definitely, because there is going to be, there are a lot of details that may come out which will hurt. And things, perspectives that we did not necessarily know from before in terms of the motivation behind this atrocious and egregious act of terror. But at the same time, we also understand that nobody really accepts these types of ideas or ideologies to lead to these types of acts, or very few people at the very least. It's a statistically insignificant number of people that would feel that. So the risks are there definitely for re-traumatization. But we also look towards our faith and towards one another and towards our community to be those means of support to us through this difficult time.
Are you finding that more people are coming to talk to you and other members of the faith community?
Yeah, I mean, we do still have these conversations, absolutely, because the issue is not simply limited to that senseless act of violence and terror on that fateful day. It's much deeper than that, because we're dealing with, elements of hatred that exist within our society in the form of Islamophobia as well as other forms of discrimination. And so these are ongoing conversations that are happening within our communities to be able to determine what are the best means to combat these various forms of hatred and of Islamophobia so that no community has to ever suffer this type of tragedy.
How have those conversations evolved over the past couple of years?
Well, to be honest, that there are a lot of concrete steps that have been proposed on different levels, in terms of, for example, governments, whether it's municipal or provincial or federal. And those ongoing conversations are what, continue to develop to be more concrete actions. And so, for example, locally here in London, we have an anti-Islamophobia strategy that is being implemented.
Yes, hopefully a lot has changed as well, and important to have those discussions for sure. This is a tough question. What would justice look like to you in this case?
Well, justice is, we have to allow the judicial process to take its route. And we know that it is a process in and of itself. But the expectation is justice for the family and for the community is to be able to, first of all, the criminal gets what should be a deterrent, really, for anyone else that would consider doing such an egregious act or anything that would lead up to that.
And let me just ask you, we know that the sole survivor was a young boy. How is he making out?
I mean, he's doing as good as somebody in these circumstances can be. Of course, it remains challenging and difficult. And I know there are a lot of concerns amongst people about, for the family members and whatnot. But, the family has also requested, privacy, and that's something that, we will respect. And the expectation is all parties would also respect that level of privacy, especially during this time.
Absolutely. A very important message to send. And I want to thank you for coming on to share your thoughts on this very important time as well.
Thank you for having me, Hannah. I appreciate it.
Abd Alfatah Twakkal is the chair of the London Council of Imams. Thank you, sir.
Thank you.
For more perspective on today and the jury selection in a case like this, I want to welcome Wally Opal. He's the former Attorney General of British Columbia, also presided over several high-profile trials as a BC Supreme Court judge, now a senior counsel at Boughton Law in Vancouver. Welcome to the program.
My pleasure.
Let's talk about selecting a jury. How has that changed in the past couple of years?
Well, the law in Canada and jury selection has changed significantly since the Stanley case. The Stanley case involved the shooting of Colton Bushy, a young Indigenous man in Saskatchewan. An all-white jury acquitted Mr. Stanley of the shooting, and considerable criticism was leveled at the system and at the jury selection system. First of all, it was argued that the jury was all white. It had no Indigenous people on it. And secondly, the selection process itself, which involved a preemptory challenge system. In other words, counsel for the defense could preemptorily challenge jurors without giving a reason. That's what preemptory means. You don't have to give a reason as to why you're challenging a particular juror from serving on the jury. As well, the Crown had an unlimited number of what's called stand-asides. So the Crown Counsel could say, I'm going to stand this person aside. So it was argued that that manipulated the jury process system. And so what we need is an unbiased jury, one that's free of any kind of biases. At the same time, you want a jury that's made up of one's peers, a jury that's represented by the representative of the public, a diverse jury. So those are challenges that the system has always had. But now what's happened is by amending those sections of the criminal code that allowed for preemptory challenges, you now can have challenge for cause. You can always have challenge for cause. So a counsel can then go before a judge now and say, I have reason to believe that this juror may be biased, or it's up to the judge to make that decision. We want jurors who are free of any kind of bias, free of any kind of pre-notions or pre-knowledge from the publicity in the media or on the internet. Now you have cell phone cameras and cameras that give all kinds of information that may at times render a fair trial impossible. Or at least compromise. So those are things that now have to be taken into account for any type of high-profile case. And I expect what the judge here would do in this case is speak to the jury panel at large and tell the jury panel, look, you have to try this case fairly. You have to dispense whatever prior knowledge you may have, and if you're chosen as jurors. So.
It sounds like, is it fair to say judges are a bit more involved now?
Well, I think we're more aware of what's going on in the public, and the public now has more access to information because of the internet than any time in the past. And between the media and the internet and phones, there's an unlimited number of sources from which members of the public can have a preconceived knowledge of what the event is all about. And of course, we want a jury of 12 people who have no prior knowledge, or if they do have prior knowledge, that they would dispose of that knowledge and keep that to themselves and render a fair verdict. That's what we want. The last thing we want in our system are wrongful convictions, or convictions that are rendered on extraneous grounds and not on the evidence that's before the court.
So you're sitting there, for example, what kind of examination would a judge make of a prospective juror?
Well, the first thing the judge would say, I would expect, is, are you able to freely try this case between the Crown and the defense without any kind of preconceived knowledge? Are you capable of being fair between the Crown and the defense? Are you capable of rendering a fair verdict here and dispensing with any prior knowledge that you may have through outside sources? So that's what the judge has to ensure. So the judge's task is now more proactive, and the judge needs to be more involved in the process, because the stand-asides and the preemptory challenge system that was previously available is no longer available. So there's a greater scrutiny to ensure that jurors come with an open mind and with fairness. And that's what the judge has to ensure.
Oh, yeah, I want to thank you for joining us and helping us understand this process. Really important.